In Penal Code Section 646.9, California law defines stalking as repeatedly following or harassing a person and making a credible threat against them or their family. Now, our common sense notion of stalking is following a person, gathering a bunch of information about a person, and that can contribute to the crime. But in California law, for it to be the crime of stalking, the person also has to make a credible threat. Now, stalking is a wobbler, which means that it could be filed as a misdemeanor or a felony. If it's filed as a misdemeanor, the person faces only up to a year in county jail. If it's filed as a felony, the person faces up to 5 years in state prison, and sometimes the judge can even make the person become a registered sex offender for life and be on Megan's list. So a conviction is really devastating for a person. Now, that said, stalking is one of those crimes where a lot of innocent people get wrongly accused and unfortunately wrongly convicted. And we see that for a number of reasons. First of all, the threat that was made may not be credible. It may be that the person was just kidding, that they weren't trying to put the alleged victim in fear. Also, sometimes we find that the person accused of stalking really was engaging in constitutionally protected free speech. And sometimes we find that a situation was just blown out of proportion, and we have a client who was either misidentified or was wrongly accused. And a lot of people who claim to be stalking victims are really narcissists, and they relish the idea that they're being stalked, and they imagine things that really aren't happening. And it's very common for there to be false accusations. Here at Schaus Law Group, we've had a great record of success over the years at defending people who are charged with stalking and getting charges reduced or even dismissed.